Okay, how's that looking?
Yep, I can see that.
Great, good. Looks like we might finally be cooking with gas. Good. Okay, and it's time, so we should probably get started. Thanks. Okay, kia ora koutou, everyone. Thank you for joining us for this, the third and final in this series of LIANZA Standing Committee on Copyright webinars. Today, Sarah Powell and I will be talking about mass digitisation and orphan works. I'm Kim Gritschlag. I'm the Manager of Collection, Development and Description at the National Library of New Zealand.
And I'm Sarah Powell, Copyright and Open Access Advisor at AUT.
Thanks to everyone who has muted themselves. We are going to be recording this, so it's good if you can keep mute on until the end when we will have some question time. So let's get underway.
Also, today we're going to talk to you about defining what orphan works are, due diligence search, how to conduct one, some practical advice, mitigating risk, mass digitisation, Copyright Act review, issues paper, and at the end we'll have time for questions as well.
So I'm going to start on orphan works and talk about the definition of them, talk about how works become orphaned, talk a little bit about works of unknown authorship, and just talk about why orphan works are a problem for New Zealand libraries. The definition that I like is the definition from the United Kingdom Intellectual Property Office, which I've got here on the screen: creative works that are subject to copyright, like a diary, a photograph, a film, or a piece of music, for which a rights holder or rights holders are either unknown or cannot be found. A key thing to note is that an orphan work is assumed to still be in copyright. How works become orphaned? They become orphaned for a range of reasons, including that the rights holder for the work is known but can't be located. The identity of the rights holder or creator was once known but's been lost over time. The identity of the creator was never known. For example, the work was published anonymously or it was never published. It's not possible to determine who inherited and now owns the copyright of a particular work. One of the reasons why works become orphaned is that copyright is automatic. There is no requirement, like in a patent, to register, for copyright creators to register their works to qualify for copyright. So there's no one nice, easy, central place to go and look and see who owns them or something. Another problem of orphan works is that as long and increasing terms of protections are being agreed to, it's making it more and more difficult to track down rights holders. It's also worth noting that the category of orphan works doesn't exist in New Zealand's copyright legislation. So when libraries in New Zealand digitise and make orphan works available, even when they've done a really thorough diligence search, they're operating outside New Zealand's copyright law. The New Zealand Copyright Act does, however, use the term unknown authorship and defines this as if the identity of the author is unknown, or in the case of a work of joint authorship, if the identity of none of the authors is known. It also goes on to talk about the identity of an author shall be regarded as unknown if it's not possible for a person who wishes to ascertain the identity of the author to do so by reasonable inquiry. Unknown authorship in the New Zealand Copyright Act includes anonymous and pseudonymous works where the identity of the author or authors obviously is unknown. In New Zealand, the term for unknown authorship is 50 years after the work is made available to the public by an authorised act. Obviously, you can't have a term that relates to the death of the author since you don't know who the author is. For a library wanting to digitise and make a work of unknown authorship available, to do this under Section 67 of the Copyright Act, but only after they've completed a reasonable inquiry to ascertain the identity of the author, and it's reasonable to assume that copyright has expired or that the author died 50 or more years ago. The Act is silent on what comprises a reasonable inquiry, but Sarah's going to be talking about that shortly. Why orphan works are a problem for New Zealand libraries is, as I noted above, there's no category of orphan works in New Zealand's copyright legislation. So libraries who want to digitise and make available orphan works either have to take a risk and use the works without permission, risking a claim of copyright infringement should the rights holder reappear, or choose not to take a risk and not digitise the works, leaving them only available to a few people who can come to the organisation, even when in many cases the copyright holders would recognise the value of making their works more widely available and would not object to the use of their works. Orphan works are also a problem because of the number of them and the resourcing needed to address them. It can take an organisation wanting to use an orphan work a very great amount of time and resources to try and identify and locate owners, and the success rate for this can be quite variable and often not very high, and we're going to talk about an example of that a little bit later. While we don't have good figures on the total number of orphan works in New Zealand library collections, partly because you can only identify the number of orphan works after you've completed an unsuccessful diligence search, the British Library has previously estimated that 40% of all print works are orphan works. And as I said before, the longer terms of copyright duration also increase the likelihood that more works will become orphaned, as it makes it more difficult to track down who currently holds the rights to a given work. So I'll hand back to Sarah now.
Thanks, Kim. So just to reiterate what Kim has said, it is important to note that a work won't become an orphan work until you have exhausted all avenues to find the copyright owner. So searching for a copyright owner is standard practice when you're releasing images of copyright works online. So keeping a good record of your search is important because it could then turn into a due diligence search. So what is a due diligence search? It is a thorough investigation to find the copyright owner of a work, and it's called a reasonable inquiry in that one section in the Act. There's no set steps or definition of what constitutes a due diligence search within the Copyright Act either. And it's also important to note that a due diligence search is only as good as the information you have about the object, and this will vary on the information available to you. So for libraries, most publications will have a known author, which will be a starting point for your search, but for museums and galleries or for other objects that you have in your collections, especially photographs, there may be no information about the maker on the object or even in the collection management record at all. Next slide, Kim. But why do we need to do it? Simply put, if no copyright owner can be located, then the work must be treated as an orphan work and extra considerations must be taken into account before publishing a copy of the work. If a copyright owner does come forward when you have published it, then you'll have proof that you have been unable to find them. And then you can negotiate copyright permission with the owner. There have been no known cases of copyright owners coming forward and taking legal action against a cultural institution. That being said, there is still an element of risk, so it is important to record your searches. And just another important thing to note, if you have a known contact for a copyright owner and they do not respond to you, so if you've sent them a letter and they just don't respond, but you know that they live at that address, that does not make the work an orphan work. It means the copyright owner is exercising their right to not grant permission, or they've genuinely not received the letter. So Australian copyright law is very similar to ours here in New Zealand, and the National and State Libraries Australia have released a position statement on orphan works and due diligence searches. So they've outlined principles for institutions and individuals who are wanting to use orphan works, which are a reasonably diligent search to find and locate the copyright owner will be conducted before the work is used. Any use of an orphan work will be non-exclusive and will seek to provide clear and adequate attributions of the rights owner if known. If the copyright owner appears at a later date, restitutions may be provided in appropriate circumstances. However, these will take into account the creative efforts and investment made in good faith by the user of the work. And the use of orphan works will respect any protocols relating to Indigenous materials. So these are quite good principles, and they relate quite well to New Zealand as well. And I put the link there where you can read the whole statement. It's very interesting. Next slide, please. So how do we do it? So a common example of an orphan work at Auckland Museum in my previous role was a work where the author had passed away less than 50 years ago. So the work was still in copyright, and the next of kin had to be traced. So these are all the steps that I took. So I'll walk you through them. Firstly, I did a Google search, and I did their name, and I filtered it by the country, New Zealand. I also looked at Te Papa on collections online, because I know that if Te Papa has it online, then they usually have the copyright owner and they will share a contact in most cases. I looked at the Find New Zealand Artists website as well, and this is to help find information on artists that other institutions may have within their collections. New Zealand Biographies Tiara database is really good as well. Find more information on the artists, who they married, where they lived, and where they died. Archway was probably one of the main places that I found information, and this was through people's probates. There's also some business paper material and also some divorce proceedings as well on Archway. You can either view these files in person if you're in the city where archives is located, or you can request a digitized copy, but that does involve a fee. Using births, deaths and marriages is also really good to trace family members, and also Family Search, which is a free website which has digitized probates, and sometimes there's quite a lot of probates on there that you need that are already digitized and online. There's also a really good website that someone has put together, a family history researcher, and it's a New Zealand cemetery searcher. It's a website with all the cemetery searches on one page, so you're able to kind of search what cemeteries and what location quite easily. So when you're looking at cemeteries, I know it sounds quite morbid, but you're looking at gravestones, you're looking for death dates, you're looking to see if there's a wife or a husband or any children with the same kind of names that may have been related, and if they've passed away as well. And the other place to search is the company's search as well, which has a register of directors' names and addresses, which are usually all publicly available too. But like I said before, usually a probate would turn out to be the best avenue to find a copyright owner, as it states the next of kin or the executor of the will. But as you can imagine, searching probates can go on for multiple times if the husband or the wife of the original author has also passed away. And once you have a name of a spouse or a son or a daughter or a niece or a nephew that's named in their will, then you just have to hope that the women remain unmarried, because tracing them once they're married is just impossible. So once you have a name, you can look in the white pages or the electoral rolls. You can phone people with similar sounding names that are in the same region. So there might be 5 people with the name J. Doe in Timaru. So you just would ring them and ask if they're related to a certain person, just to find a living relative. When you have a list of orphan works, next slide, sorry, Kim. So when you have a list of orphan works that require more in-depth investigation, then the best way to record all of your searches is in an Excel spreadsheet. You can also create a document and keep it in a folder with all the information, images of probates as well, and any dates and notes are very helpful. So the date that you called someone, the date you sent a letter. And as you can imagine, it's very time consuming, it can be costly, and it takes a lot of patience and a good sense of investigation, I guess. It's almost like being a private detective. But at Auckland Museum, I was lucky to have 3 volunteers who were interested in family history, and I actually trained them to conduct these due diligence searches. And I've actually also created a resource for this, so I'll share the link with everyone at the end who's interested in it. But the best part about doing the search is that if you do find the copyright owner and get copyright permission, it is very rewarding. but this happens very rarely as most searches end up at a dead end. So mitigating risk. Under New Zealand law, making good faith attempts to identify and contact the copyright owner does not protect you from legal action. It is important, if you have any doubts at all, to speak to a lawyer. Kim and I are not lawyers, we're just offering advice today. So any risk assessment will depend on what type of work the orphan work is and what the use is. So if it's for a commercial work like a postcard or a book, then that is a bigger risk. And most GLAMs tend to only use these works for non-commercial use only. So again, just make sure to mitigate that risk that you keep really good records of all the searches that you conduct. And it is a good idea to have a copyright takedown notice on your website under the terms of use. And that way the copyright owners can easily find someone to contact if they have a problem with it. And you can also consider you having an orphan works rights statements for users. So if people see things online, they usually want to reuse it right away. And having a clear statement to let them know that the work is an orphan work and it will carry risks for them if they do want to reuse it is quite good. And also be prepared for a rights holder to come forward and be prepared to pay a fee to them to license the work to use as well. So Kim's just going to talk next about an example of a mass digitisation project.
Okay, so yeah, I'm going to talk about the digitisation of the New Zealand feminist magazine Broadsheet. Broadsheet was published between 1972 and 1997 as 214 issues. The magazine's an important historical resource for social history of the period. There were many individual contributors to Broadsheet, and they each retained copyright over the material they contributed. The National Library had been considering the digitisation of Broadsheet since about 2005, but the anticipated amount of work needed to clear copyright meant that plans stalled a bit. In 2016, the library was approached by a former editor of Broadsheet who was interested in digitising the magazine. So we decided to undertake some initial exploration of what would be involved in clearing Broadsheet for digitisation. We began by searching Index New Zealand, which had indexed many of the articles from Broadsheet, to identify the individual contributors. We identified nearly 1,000 individual contributors in looking at INS. We then took a pilot of a sample of just over 100 of these contributors and started to search for contact information and contact them. What we found in that little sample was we found contact information for 64% of them. We found that 18% of the contributors in our sample had died. We got about a 70% response rate when we made contact, and that on average it took about an hour per contributor to do the searching and contacting. Many of the people who responded were happy with their content being made available under a Creative Commons by non-commercial license, but a few wanted a different license, a tighter license, or more clarity about the license that we were proposing. At this point, our work on Broadsheet halted because of the resourcing commitment required. But then later on in the year, we were able to hire some contract staff to undertake some more work on Broadsheet, kind of to gauge the full extent of the work needed to identify and contact all the rights holders. We had a pretty good idea that the list of contributors we'd culled from Index New Zealand wasn't comprehensive. So what we did the second time to identify contributors was we actually looked at we looked at just over half the number of issues that had been published, and this gave us a list of 1,453 individual contributors. So our next step was to try and contact them and find contact details for them and contact them. We were lucky that one of the contractors working on the project was very familiar with the New Zealand feminist community, so that made life a bit easier. So we searched for nearly 1,000 contributors, and the figures for that search meant that we found definite contact details for only 41% of them. We had 32% of them where we thought we knew who the right person was, but we would have needed to contact them to confirm this. We had 5% of contributors who had died, and what would be required for rights clearance in those cases would be a bit what Sarah's talked about, going through probate, trying to find out who was managing their rights now. 3% of the articles were from other publications, which meant obviously we'd have to contact those publications regarding the clearance. And for 18% of contributors, we had absolutely no leads about how to find them. At this point, we stopped and did our sums. The cost to date had been quite considerable, and we estimated that to complete the clearance, we'd need to spend an additional 4 times the amount we'd already spent. At that point, we didn't have the resourcing to complete the work needed. We didn't feel we could take the risk of putting it out there without completing that work, so we stopped. We did, however, learn a lot from our work on Broadsheet and some other digitisation projects, and so now we actually have a draft diligence search approach for published items. This isn't the end of the Broadsheet story, though, because in 2016, the University of Auckland digitised and made it available only to staff and students at the university. They did this under sections 55 and 56 of the Copyright Act, 56A of the Copyright Act. After they'd done that, the university spoke with some of the original Broadsheet editors, and they were keen to see the magazine made publicly available. So through the editors, the university contacted as many of the rights owners as possible to let them know that they wanted to make the digitised issues publicly available, and to reassure them that they still owned copyright and that no one could do anything with the works without their permission. All of the contributors who they contacted gave permission to make the content publicly available. And since the content has been available, the university says it's received feedback from various authors pleased to see that the work is publicly available. The website, which is there on the screen, that the University of Auckland has made the content available, has a statement which invites copyright holders to contact the university if they don't want their work to be publicly available. But to date, the university hasn't been asked to remove any content. So I'm going to hand back over to Sarah.
So I just thought it would be good to go over a couple of examples of institutions that do have orphan works rights statements on their websites and copyright takedown notices. So you'll see here, this is the Auckland Museum example. And this orphan work statement, copyright undetermined, untraced rights owner, was developed by Ainsley Jew at Auckland Museum a few years ago. And it's based on the National State Libraries Australian principles that I talked about before. So in a quick search on the Auckland Museum collections online shows that around 3,000 works are online with this statement at the moment. And it's just good to point out here that the majority of these will be objects that are deemed to be still in copyright, but will have little or no information about who the copyright owner is in the collection management system. And the copyright takedown notice is pretty standard and is very clear, so that's good. Next slide. And the Sargeant Art Gallery example is they use the term copyright orphan, and they state it really clearly that the image cannot be reused. It's a different right statements in Auckland Museum, but it's still clear that it's an orphan work. And they've also got a copyright takedown notice as well. Next slide. So the impact of orphan works is huge, and it creates a chilling effect. This is largely because libraries, galleries, archives and museums are often not the copyright owner of works in their collections. And institutions are mandated to provide access to collections, and more increasingly online, and high expectations from users for immediate access as well. And the exceptions in the Copyright Act are limiting on what libraries can do, or libraries and archives, not museums. It's limiting on what they can do, and it's very confusing. And this creates, across the whole sector, a huge risk averseness, which then in turn creates a chilling effect to online access to collections within LIANZA in New Zealand. So as you can see, this whole, the landscape of orphan works just locks up a whole lot of works. So, next slide. Kim's going to talk to you about overseas regimes for orphan works and how they deal with them there.
Okay. So yeah, overseas, they've also experienced this chilling effect. They have looked at ways to address the orphans' works problems to enable them to be opened up. And MB in their issues paper actually asked a specific question about the problems or benefits of overseas regimes for orphan work, so we thought it would be useful to just briefly look at these. The first thing I would say is that about any regime for orphan works overseas is that almost all of them include some form of diligence search. So the first one I want to talk about is exceptions for cultural heritage institutions. And so in 2012, the European Union passed its Orphan Works Directive, which required member states to introduce a new exception to their legislation to permit certain uses of orphan works. The UK passed regulations in 2014, which provided an exception for publicly accessible libraries, educational establishments and museums, as well as archives, film or audio heritage institutions and public service broadcasting institutions, to make certain non-commercial uses of orphan works in order to achieve the aims related to their public interest mission. So they did tie it very much to that public interest mission. What happens is, after completing a diligent search, cultural heritage organisations of the type I've just mentioned may make orphan works accessible to the public and may copy the work for the purpose of digitisation, preservation, cataloguing or indexing. The exception only covers the use of literary works, cinematographic works, audio-visual works and sound recordings across the EU. So it doesn't include standalone artistic works like photographs, maps, plans and drawings, although if an artwork's included embedded in a work that's covered by the directive, like in a literary work, it'll be okay. So still the end result is a bit unsatisfactory in that a significant amount of the material that's in cultural heritage organisations is not in scope of the directive. The cultural heritage institutions which make use of the orphan works exception are required to log their diligence searches with what I think is the wonderfully named Office for the Harmonisation of Internal Market. This is to help increase the chances of the works being reunited with their owners, and also means that other institutions can benefit from the diligence searches that institutions have already performed. You may have seen recent online comment about the UK feminist magazine Spare Rib, which was digitised under the orphan works exception. There's a very real concern that if there is a no-deal Brexit, the British Library will need to suspend access to the Spare Rib archive, because the library is only protected from legal action under the EU Orphan Works Directive. The second regime I want to talk about is limited liability. This was a regime considered but not adopted in the United States as part of a proposed Orphan Works Act. What it would do is limit to reasonable compensation the amount payable to a rights holder should they reappear if a cultural heritage institution has used their work. Like other schemes, it still relies on the organisation wanting to use the work to complete and document a diligent search. While such a scheme would decrease the risk to the organisation wanting to use it, it still leaves quite a fair bit of uncertainty, and it does have a significant drawback in that it requires both parties to undertake litigation. So the rights holder comes back, has to basically take the organisation to court to say you've used my work unlawfully. So probably not a great scheme. There's also licensing schemes. So several countries operate licensing schemes where individual works can be licensed. So the UK one works a bit like this. The person or institutions wanting to license the work still have to have first carried out a diligent search and established that the owner of the copyright work cannot be identified, or if identified, can't be located. The details of that search need to be recorded in the UK Orphan Works Register. Unlike the orphans work exception, all categories of material can be licensed under this. The search that the organisation does has to be verified by the UK Intellectual Property Office. They don't define diligent search, but they do provide some guidance about it. The Intellectual Property Office licenses the work. The licence is non-exclusive. Its use can be both for commercial and non-commercial. They have both types of licences. Sufficient acknowledgement must be given to the missing rights holder, and the licenses last for only up to 7 years, and then you have to do it all again. There's money involved, there's a fee to be paid, there's an application fee of £20, British pounds for one work, scaling up to a maximum of £80 for 30 works. There's also the license fee itself, which is quite small. But if you wanted to do a really large amount of work, as many cultural heritage institutions will, then the costs are going to quickly mount up and become quite prohibitive. Another form of licensing is extended collective licensing. This is where there's a licensing agreement between the organisations wanting to use the work, libraries, and a collective management organisation. This is a model that's found in Norway, Denmark and other Nordic countries, and a few other countries as well. The principal advantage of this kind of a scheme is that there's no requirement to do a diligence search before using a work. The principal disadvantage is the cost, as they're usually quite expensive because they have very extensive coverage. But quite a few organisations have commented that the size of the fee to be paid is out of proportion when, you know, many rights holders will never surface, and so you've paid all this money on the off chance that they will, and they won't. So it is considered quite an expensive system. Anyway, that's just a quick look at some of the regimes overseas for dealing with orphan works.
So back to me. So as most of you will know by now, the Copyright Act is currently under review, and MB are seeking feedback on the issues paper that they released. So we have until the 5th of April to submit our feedback, either as an individual or even on behalf of your organisation. And these are just 4 questions that directly relate to orphan works. So have you ever been impeded using, preserving, or making available copies of old works because you could not identify or contact the copyright owner? Please provide as much detail as you can about the problem and its impact. I just want to note there that not all orphan works are old works. Many of them are, but not all of them. So you could even put that in your feedback to MB. Question 72, how do you or your organisation deal with orphan works? Your general approaches, your policies, and can you describe the time and resources you routinely spend on identifying and contacting the copyright owners of orphan works? So also, it's important to note that even if you don't deal with orphan works, that MB should know this, and also your reasons why. It could be that it's just too much time and resources for your institution to commit to, but I think it's important that MB know that people are not dealing with orphan works because it's too much of an issue. Question 73, has a copyright owner of an orphan work ever come forward to claim copyright after it had been used without authorization? If so, what was the outcome? And question 74, what are the problems or benefits of the system of using an overseas regime for orphan works? So next slide. So when you're submitting to MB, they've asked us to focus on the problem, not the solution. It doesn't mean that you can't offer solutions, but it's important to just upfront give them the problem. First, consider the proposed objectives when you are writing a response. Back all of your issues, if you can, back it up with evidence, and I'll talk about what evidence they want next. And also talk about what is working well. So if there's some exceptions or something in the Copyright Act that is working well for your institution, make sure you let MB know. So when you're writing your responses to the questions, just think about what is the issue, why is it an issue, how does it come about, who is affected by it, and on what scale. And I've just popped the link to the issues paper down the bottom, and there is a Word document that MB have supplied with all the questions and a blank space for you to put your response in to make it easy for you to submit. And you don't have to answer every question either, just answer the ones that are relevant to you. So MB want to hear about your issues, but they also want some evidence. So they want peer-reviewed academic research if possible. If you don't have access, then visit your local library. They should be able to provide you some access. They want to hear your personal experience and anecdotes. And they also probably would prefer, over the other evidence, numbers and data. So looking at the time cost-based analysis of managing copyright. And also they want to know the scale of the issue. So when you're writing your submission and putting together a response, just think about what issues with copyright have stopped you from completing a project or from not using a work in a project. If the cost of copyright fees have ever stopped you from using a reproduction of a work for a non-commercial purpose, and what impact it had, and how much time and resources you've spent trying to manage copyright, find a copyright owner, or conduct a due diligence search. And that's it, but I've just put some useful resources there. the due diligence resource that I put together, there's a bit.ly link for that. Victoria Leachman's flowchart of death, which is great for working out copyright duration. And if you want, you can have a look at the copyright chatbot that I've created that will help you determine the copyright status of a work as well. And then there's the MB Issues paper link again. So thank you for listening, and are there any questions? No questions?
I've got a question. This is Victoria from Te Papa. I'm just wondering who else here has orphan works issues. Both Sarah and I have talked about this quite a bit, and I'm just wondering if anybody else in this webcast is facing the same issues that we are in terms of the amount of orphan works in our collections.
Victoria, it's Kim here from the National Library. Unlike you, we haven't kind of done any counting. I think, what was it, your last count's about 55,000 orphan works in your collection? Is that right?
That's
yeah.
Right. Yep.
Yeah. But I mean, if we take that British Library 40% figure, then ours is going to be pretty huge as well. Probably, I would suggest more than 55,000. Yeah.
Yeah, that's the end counting bit for us as well. We're not quite at the point where, I mean, it's after all figuring out what's what, really.
Yeah. What about anyone else? Has anyone else done any exploration of this in their own institution? I think for us, the orphan works problem will get bigger over time, because more of what we will collect under National Library legal deposit regime will be kind of what I would call informal collaborative works, like, you know, works that are created online, and that will just make it, I think, even harder to identify who is the rights holder and to trace it.
I agree. I think there's a lot of work we do at acquisition, the acquisition phase now, knowing that if we don't do it then, we're going to be facing an orphan works problem.
Yeah.
Less than a year after we finish the acquisition.
Yeah, that makes good sense. Yeah.
Any other questions? Is there anyone that is considering writing a submission on the Copyright Act review, other than Victoria and myself and Kim and Zoe? Motat, I see you're there. Motat Library is drafting one. That's great.
Cool.
Cool. Well, I guess if there's no other questions,
we'll say thank
you and good for joining us.
Yeah. LIANZA will be making the recording of the webinar available. Oh no, hang on, there's some more. I see more chat.
Said thank you.
Great. Okay, that's our pleasure. So yeah, they will make the recording available and circulate the link. So yeah, thanks for listening in, and yeah, thank you.